Hi, good day everyone. Before we proceed to my presentation, I just want to introduce myself. I am Nelson Lasco from BSA 1, your reporter for today. First, let's talk about laws promoting equity and safety. Laws promoting equity in the workplace were passed during the 1960s and 1970s to protect the rights of minorities, women, older persons, and persons with disabilities. And these are some examples that laws promote equity and safety in the workplace. There is the Equal Pay Act, the Title VII of the Civil Rights Act, the Age Discrimination in Employment Act of 1967 that prohibits discrimination in employment against persons between the age of 40 to 70, the Title IX of Education Amendments of 1972, Pension Reform Act of 1974, Age Discrimination Act of 1975, and also Pregnancy Discrimination Act that prohibits discrimination on the basis of pregnancy, childbirth, or any related medical condition. And of all these laws, probably the most important in business is the Title VII of the Civil Rights Act. It is originally passed in 1964 and amended several times. The Title VII is the section of the Federal Civil Rights Act that prohibits employment discrimination on the basis of race, sex, religion, color, or national origin. The objectives of anti-discrimination legislation is to ensure that individuals are given equal opportunity in the workplace. The Civil Rights Act also created the EEOC, which is Equal Employment Opportunity Commission, to enforce the provision of Title VII. And among other things, the EEOC assists business in designing affirmative action programs. These programs aims to increase job opportunity for women and minorities by analyzing the present pool of employees. They also identify areas where women and minorities are underrepresented and establishing specific hiring and promotion goals along with the target dates for meeting those goals. Okay, next is the Equal Pay Act of the 1963. It mandates that women and men be given equal pay for equal work. Difference in pay was permitted in cases of affirmative defenses such as seniority, merit, performance, or qualifications. They also created the Americans with Disability Act of 1990 that prohibits discrimination against individuals with disabilities in all areas of public life, including jobs, schools, transportation, and all public and private places that are open to the general public. And despite these laws that I mentioned, inequities in the workplace still exist. Okay, the Congress passed law that seeks to improve safety in the workplace. By far, the most significant of this is the Occupational Safety and Health Act of 1970. It was enacted to ensure that the health and safety of the workers would be protected. The Occupational Safety and Health Administration, or OSHA, enforces the act and make regular surprise inspection to ensure business maintains safe working environment. Even with the passage and enforcement and safety laws, many employees still work in unhealthy or dangerous environment. Safety experts suspect that companies unreport industrial accidents to avoid state and federal inspections and regulations. The current emphases are increased productivity has been cited as the main reason for the growing numbers of such accidents. Competitive pressures are also believed to lie behind the increasing in manufacturing injuries. Overworked employees are often cited as a primary factor in careless accident, both in the United States and in other countries. Okay, gatekeepers and stakeholders. Gatekeepers include accountants who are essential to certifying the accuracy of financial information, as well as lawyers, financial rating agencies, and even financial reporting services. These groups are critical in providing information, allowing stakeholders to gain an understanding of the financial position of an organization. Most of gatekeepers operate with professional codes of ethics and face legal consequences, or even disbarment. if they fail to operate within the agreed-upon principles of conduct. Therefore, there is a strong need for gatekeepers to uphold ethical standards and remain independent through using standard methods and procedures that can be audited by other gatekeepers, the regulatory system, and investors. Next is accountants. Accountants measures and disclose financial information with an assurance of accuracy to the public. Managers, investors, tax authorities, and other stakeholders who make resource allocation decisions are all groups who use the information provided by the accountants. Accountant makes specific assumptions about their clients. One assumption is that corporation is an entity separate and distinct from its owners, and that it is continues to operate as such in the future. Another assumption is a stable monetary system such as dollar in its place as all necessary information concerning the business is available and presented in an understandable manner. Accountants have their own suite of rules. One is that if there is a choice between equal acceptable accounting methods, they should use the one least likely to overstake and misdirect. Okay, last, risk assessment. Another critical gatekeepers group are risk assessors of financial product. The top 3 companies in the world that independently assess financial risk are Standard & Poor's, Moody's, and Fitch. They express risk through letters ranging from AAA and highest grade to C to the lowest grade. Different rating services use the same letter grades but use various combination of upper and lowercase letters to differentiate themselves as early as 2003. Financial analysis and the 3 global rating firms suspected there were major problems with the way their models were assessing risk. In 2005, Standard & Poor's realized that algorithm for estimating the risk associated with the debt packages was flawed. As a result, it asked for comments on providing its equations. In 2006 and 2007, many governmental regulators and others started to realize what the rating agencies knew for years. Their ratings were not accurate. Moody's, Standard & Poor's, and Fitch all violated the code of conduct that required analysis to consider only credit factors, not the potential impact on Moody's or an issuer or an investor or an anti-market participants. These companies become overwhelmed by an increasing in the volume and sophistication of the securities they were asked to renew. This failure to adequately account for risk is having consequences for financial credit rating firms. This creates a conflict in interest problem and affect the reliability of the ratings. No organization is exempt from criticism over its level of transparency.